The tenancy reforms in the Renters' Rights Act come into force on the 1st of May 2026. And if you're a landlord or a letting agent, do you know exactly what you must do? And more importantly, what you must not do? And what happens if you don't do what you're supposed to do or not supposed to do? In this video, I go through exactly that, so you can take the Renters' Rights Act in your stride. I'll start with explaining what happens on 1st of May, and then, importantly, I go through 10 things that landlords must stop doing on the 1st of May. And who am I? I'm Suzanne Smith, a former corporate solicitor turned landlord, and I run the Independent Landlord website and this YouTube channel to bring reliable information to everybody in the private rented sector for free. And you can keep up to date with what's happening during this period of immense change by subscribing to my free newsletter on the independentlandlord.com/subscribe. Right, I'll crack on with it, starting first with what landlords need to know about the 1st of May, also International Workers' Day, when all the tenancy reforms in the Renters' Rights Act come into force for both existing and new tenancies all at the same time. All assured short-hold tenancies, ASTs, will turn into assured periodic tenancies, APTs, overnight, just past midnight. All fixed terms will end and there'll be rolling, periodic tenancies without an end date. Tenants will be able to serve a notice to quit with 2 months' notice at any time, and landlords will only be able to increase rent using the Section 13 process. And there are new rules on advertising properties for let, rental discrimination, and so on. And of course, landlords won't be able to use Section 21 to evict tenants, and instead, they'll need a valid ground under Section 8. And breaches of these rules on or after the 1st of May can lead to the local authority imposing a civil penalty of up to £7,000 for a first breach, and even up to £40,000 if it's repeated or continuing breach, or if it's an offence. So, what do landlords need to do for existing tenancies? Well, apart from complying with the new tenancy reforms, which I summarize in under 10 minutes in this video, all landlords with ASTs that were entered into before the 1st of May need to issue an official information sheet to their tenants by the 31st of May. This includes both those tenancies that have already started and the tenants are living in the property, and also those tenancies where the parties have entered into the agreement, so they've signed them, but the tenants aren't due to move in until later. And this happens with student lets in particular. The information sheet will be on the gov.uk website sometime in March. If landlords don't provide the information sheet to the tenants, they can receive a civil penalty from the local council of up to £7,000. And the starting point of this penalty in the statutory guidance is £4,000. So the next category is for landlords where there's no written tenancy agreement. Say the landlord let somebody move in, agreed the rent on a handshake, and never got around to doing a tenancy agreement. Well, these landlords will need to issue a written statement of terms to the tenants by the 31st of May. And it's not the same as issuing a new tenancy agreement, but it's confirming the terms. And landlords can receive a civil penalty of up to £7,000 if they don't do this by the 31st of May. The next category is HMO landlords with full-time students. And you think you might want to use the new ground 4A to terminate the tenancy and ask the tenants to leave any time between the 1st of June and the 30th of September. Well, you'll need to issue a written statement to advise them of this by the 31st of May, on top of the information sheet. And again, there's a civil penalty of up to £7,000 if a landlord later goes on to serve a ground 4A notice without having provided this written statement. They'll also have to give 4 months' notice in order to be able to serve a Section 8 notice using ground 4A. And what this means is that for the 2025 to 2026 academic year, it'll probably make sense to use Section 21 and serve it on or before the 30th of April at 4:30 if you're concerned that the tenants won't move out when you want them to and you don't have enough time to use ground 4A. But be aware that tenants will be able to serve a notice to quit on the 1st of May and leave 2 months later, say on the 30th of June, if they get their act together. And if your existing tenancy agreement says that there was a fixed term until, say, the 30th of August, they might end up moving out 2 months earlier because fixed term tenancies will go and they'll become periodic. So, next, what don't landlords need to do for existing tenants? These are the tenants that are there on the 1st of May. Well, the first thing landlords don't need to do is reissue tenancy agreements. The Renters' Rights Act treats ASTs, assured short hold tenancies, and assured periodic tenancies or APTs. That's this new tenancy that the Renters' Rights Act is bringing into force. They treat an AST and an APT as the same continuing tenancy and not like a new replacement. And this means there's no need to reissue new APTs on the 1st of May. In fact, you shouldn't. You can agree an amendment via an addendum to take out terms that no longer apply, for instance, removing a rent review clause, but there's no need to do this, as all you have to do is to serve the information sheet on your tenants by the 31st of May. So the next thing you don't have to do is reserve any documents because it's a continuing tenancy. Landlords don't need to reissue the tenancy documents like the EPC, the EICR, and the gas safety certificate. And be aware that from the 1st of May, they're going to be discontinuing the How to Rent guide, so you won't have to worry about that. And the third thing you won't have to do is to re-register the tenancy deposit, as the law won't consider the newly transformed APTs as new tenancies. And a fourth thing is you will not have to repay rent paid in advance. Landlords don't have to repay rent paid in advance by tenants unless they move out before the tenancy was previously due to end and they'd paid it in advance. Say they serve a notice to quit and there's still prepaid rent in the pot. And in that case, the tenant is entitled to be repaid any part of that rent that relates to days falling after the end of the tenancy. 10 things that landlords must stop doing on the 1st of May. The first one is stop serving new Section 21 notices or other notices to quit, because it will be a breach of the Renters' Rights Act to serve a new Section 21 notice or try to end the tenancy without using a valid Section 8 notice from the 1st of May. And if you do this, you could receive a civil penalty of up to £7,000. And it doesn't matter if your existing tenancy allows you to terminate by serving 2 months' notice to quit. You have a clause saying that, because any clause like that will be null and void from the 1st of May. And you won't be able to ask them to leave informally. That comes with a civil penalty of up to £7,000 as well. Number 2, stop saying that they're subject to a fixed term. If your existing AST that you entered into before the 1st of May has a fixed term in it that expires, say, on the 30th of November 2026, then that fixed term will be null and void from the 1st of May, and the tenants will be able to serve a notice to quit with 2 months' notice to expire at the end of a rent period at any time. So if they serve a notice to quit on the 1st of May, saying they want to leave on the 30th of June, you'll have to accept it, even though the tenancy agreement says they can't leave until the fixed term ends on the 30th of November, because that is now null and void. And again, if a landlord does this, they can receive a civil penalty of up to £7,000. Number 3, stop using old AST templates for new tenancies from the 1st of May, because you won't be able to use an existing AST template for new APTs, as they're likely to have a fixed term in them. And if they have a fixed term period in them, you could receive a civil penalty of up to £7,000 if you purport to let for a fixed term. Number 4, Stop requiring tenants to pay rent in advance. For new tenancies, landlords won't be able to have a legally binding clause for tenants to pay rent in advance. And if there is a clause that says they must pay rent in advance, say 6 months' rent paid up front, then the tenant can ignore it as it won't be binding. Tenants can always voluntarily pay rent in advance so long as they don't pay before a tenancy agreement is entered into, because if they do, that will be a breach of the Tenant Fees Act. Number 5, stop turning down applicants just because they receive benefits. From the 1st of May, it will be illegal to turn down applicants just because they receive benefits. This, along with turning down applicants because they have children, is called rental discrimination, and it is banned in the Renters' Rights Act. However, landlords will be able to take into account a person's income when considering whether that person would be able to afford to pay the rent. But this doesn't just mean earned income, it will include income from benefits. But you'll still be able to turn down applicants if they fail credit checks, if they get a bad reference from their current or more likely previous landlord, or you get a better applicant. You just can't have a ban on applicants who receive benefits. Or have what's called a criterion or practice, that is the equivalent. For instance, insisting that they have full-time employment or are professionals, whatever that means. If the local authority believes on a balance of probabilities that the landlord has discriminated against benefit claimants, they can impose a civil penalty of up to £7,000. And a balance of probabilities means more likely than not. It's actually not a very high level that they have to prove. Number 6, stop blanket bans on children. You won't be able to prevent somebody from viewing a property or renting a property because they have children. And you also can't use criteria designed to discourage them from coming, like saying no families. However, you will be able to refuse to let to tenants with children if there's a good reason. For instance, the property is too small or there are safeguarding issues, like if it's an HMO and somebody wants to rent a room and they've got a child. That would be reasonable to turn it down. And again, a breach of this rule comes with the risk of a civil penalty of up to £7,000. Number 7, stop renewing tenancies. As there'll be no more fixed terms, a tenancy will continue automatically and it will not renew. And if you want to put the rent up, the only way you'll be able to do this is by serving a Section 13 notice using the new Form 4A, which will be on the gov.uk website. Speaking of which, number 8, stop using any method to increase rent other than Form 4A. Because from the 1st of May, the only way to increase rent will be to use the Section 13 process with the new Form A. And don't use the old Form 4 from the 1st of May because the rent increase will be invalid. And don't rely on a rent review clause, as that will be invalid as well. And don't forget that you'll need to give at least 2 months' notice in advance of the date that you'd like the new rent to come into effect using the Section 13 process, which must be the day that the rent is due under the tenancy agreement. And you'll only be able to increase rent once a year, and you won't be able to do it via an addendum unless you've already issued a Section 13 notice and you've agreed to a lower rent with the tenants. Now, this doesn't come with a civil penalty. It's about the only thing that doesn't. But the tenant won't be in rent arrears if you increase rent by using any other method and they refuse to pay it, because they can just ignore it. Number 9, stop advertising property without a specific rent figure. You must state the proposed rent in any advertisement or listing, or even on Facebook or a notice in the local shop window. You'll have to give a precise rent figure. And breach of this comes with a civil penalty of up to £7,000 for a single breach. And finally, number 10, stop rental bidding. Rental bidding is banned in the Renters' Rights Act. And this means that you won't be able to ask for, encourage, or accept any offer of rent that is higher than the proposed rent that you have in your listing. This also comes with a penalty of up to £7,000. Right, that's a lot to take in, and I rattled through it. If you have any questions, you can ask me them live twice a month if you join my membership, the Independent Landlord Hub. There's lots of resources, templates, checklists, and training courses. And there's also a mini me called Sue's AI, which can answer questions 24/7. And she answers the questions based on the content in my hub. Everything comes included, and there are no sponsored posts or promotions. You can find out more here. If you found this video useful, please give it a like. See you soon, and hopefully in the hub.